Can you hear me?
Yes, Your Honor. Good morning.
Good morning. I think we're going to start with Mr. Young, is my understanding.
That the one that is
I don't
being,
believe you weren't able to speak with, is my understanding.
yes.
I'm not sure if anyone's in the jail. It's muted right now.
Judge?
Okay, you can hear us in the jail?
Yes.
Okay. Is there going to be video at all? Or okay, I see. Okay, on the record, in the matter of the people of the state of Michigan versus Shane E. Young, counsel can I have your appearance.
Good morning, Your Honor. George at APD on behalf of Mr. Young, who I have not met with yet, who is appearing via tablet at the jail.
Okay, Mr. Young, you can hear us, correct, sir?
Can you repeat that now? I'm sorry, I cannot hear you.
I'm just trying to make sure you can hear me. Can you hear me now?
Yes, ma'am, I can hear you.
Okay, I have a felony complaint here that you need to be arraigned on. The allegations, sir, that on or about August 30th, 2025, at South Butler Boulevard at or near West St. Joseph, which is in the city of Lansing, Ingham County, state of Michigan, that you allegedly did commit an assault, batter, wound, resist, obstruct, oppose, or endanger Officer Jared Newton, who's an officer, a police officer of the Lansing Police Department that you knew or had reason to know was performing his duties. Count one is a felony, and the maximum penalty is 2 years and or $2,000. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There's also a count two, also assaulting, resisting, obstructing an officer. This allegedly having occurred on August 30th, 2025 at 120 West Michigan Avenue, Lansing, Michigan, which is the location of the jail or the lockup. It says that you did allegedly assault, batter, wound, resist, obstruct, oppose, or endanger Sergeant Zach Johnson, a police officer of the Lansing Police Department that the defendant knew or had reason to know was performing his duties contrary to MCL 750.81D. One, and this is a felony as well, 2 years or $2,000, and a consecutive sentence can be imposed. There's a count three of alcohol, open container in vehicle. The allegations are that you did on or about August 30th at South Butler and West St. Joseph transport or possess an alcoholic liquor in a container that was open, uncapped, or upon which the seal was broken within the passenger area of a moving vehicle in a place open to the general public or generally accessible to motor vehicles, including an area designated for parking vehicles, and that this is in violation of Michigan Compiled Law 257.625A. That's a misdemeanor, and the maximum penalty is 90 days in jail and or $500 in fines, and you can be ordered to complete community service, sir. Do you understand the charges read and the maximum penalty?
Yes, ma'am.
You have the right to be represented by an attorney. Mr. Anid is placing his appearance on the record today. However, he's not had an opportunity to meet with you because the understanding is that you were causing a bit of chaos this morning at the jail. So you'll have a meeting with the public defender's office at a later time if you want to have representation by them, okay?
Ma'am, you repeat, he said I was causing what at the jail?
The understanding is that you were causing some disruption, so you were unable to meet with the public defender this morning. But the public defender can be made available to meet with you at another time if you would like to do an intake so that they can represent you, okay?
Okay, ma'am, but that's totally false. I wasn't causing no.
Okay, I'm not here to discuss whether or not it's true or false because it's not an issue for me. I wasn't there. I'm just explaining to you why you have not met with Mr. Anid yet, okay?
I understand.
Okay, so you do have the right to counsel, and you have the right to be represented by an attorney at all of your court dates. You have the right to be represented by an attorney if you're going to be questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the public defender's office represent you at the expense of the public, okay?
Yes, ma'am.
Do you believe that you would want to have the public defender's office represent you for this case?
Yes, ma'am.
Okay, so I'll note that you are requesting a public defender, and so Mr. Anid can meet with you later after we complete the arraignments this morning. And we will also enter a plea of not guilty on your behalf, okay?
Yes, ma'am, of course.
You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, this matter will continue all the way to a jury trial. You do have the right in counts 1 and 2 to have a preliminary examination because those are felony counts. You have the right at the time of the preliminary examination to require that the prosecutor put forth sufficient evidence to establish probable cause that these felonies were committed, and then probable cause sufficient to charge you as the individual who committed the felonies. Do you understand your right so far?
Yes, ma'am.
You also have the right to have your preliminary examination within 21 days of today's date, unless you waive the timeline or the court finds good cause to go beyond the 21 days. You are currently scheduled for probable cause conference before me, Judge Kristen Simmons. Is going to be on September 12th at 9 o'clock in the morning. You have a preliminary examination before me in person at the court, September 18th at 8:30. And you will receive a notice to appear. Okay, sir? Do you have any questions so far? Okay, you have the right to the presumption that you are innocent. So you're innocent until proven guilty. You have the right to require the prosecutor prove your guilt. They would have to prove each element of the charges being brought against you beyond a reasonable doubt. And they do that at a jury trial. You have the right to have a trial by jury of your peers, the right to have witnesses called to testify on your behalf, the right to question or cross-examine any other witnesses that the prosecutor calls, and the right to remain silent at your trial and not have that silence be used against you. You understand those rights?
I do.
Okay, are you currently employed?
Yes, ma'am. I work at Value City Furniture on West Saginaw. I'm a delivery driver. And I'm currently on Wednesday, I got a state exam to get my CDLA. I finished school in St. John's Tri-Area Trucking School. I take my state exam in Flint at 11 o'clock. I missed it last Monday, but I rescheduled it. I also take my state exam on Wednesday, Flint at 11 o'clock for my CDLA.
Thank you for that information. What's your home address?
My home address is 2915 Rysdale, Risdaadale Avenue, Lansing, Michigan 48911.
What's your phone number, sir?
You said my phone number?
Yes.
517 area code 648-5303.
Okay, I don't believe that I was provided your criminal history. However, I am provided a notation that you have a PPO, an alleged PPO violation. So you do have to be remanded to see the judge at the circuit court on that violation, okay? So that will be the order of the court. You will be remanded to go before the judge at the circuit court on the alleged violation that you violated the personal protective order. Mr. Anid, any additional matters for the record today?
No, Your Honor, thank you.
Okay, you're all set, sir. Thank you. It is icicles in this building.
It's only the beginning. It's gonna get worse.
I know.
You have work? No, he had something new.
Okay, you can hear us? Okay, very good. On the record in the matter of the state of Michigan versus Martin Casada, council appearance.
Thank you, Your Honor. George Annette, APD, on behalf of Marcus, out of purpose of arraignment only this morning.
Good morning.
Okay, are you-
Good morning, Judge.
Good morning. Are you Martin Casada?
Yes, ma'am. That'd be me.
Okay, Mr. Casada, I have a felony complaint that I need to arraign you on. The allegations of that order are about August 30th, 2025 at 3900 Burnway Drive, apartment 206, Lansing, Michigan 48911, that you did allegedly attempt to commit the following said offense, and in the attempt did act towards the commission of that offense. That is an attempted home invasion third degree, allegedly having failed to in the perpetuation or the was prevented in the execution thereof in contrary to MCL 750.92. The allegations is that you did allegedly attempt to break and enter or did enter without permission a dwelling at 3900 Burnway Drive, apartment 206, while entering, present in, or exiting the dwelling, did commit a malicious destruction of a building less than $200, which is a misdemeanor, contrary to MCL 750.11A4. Count one, attempted home invasion third degree, however, is a felony. And so the maximum penalty that you're facing in count one is 2.5 years in prison and or $1,000 in fines. Court shall order law enforcement to collect the DNA identification profiling sample. Count two is malicious destruction of a building less than 200, alleging that on or about August 30th, 2025, at the same address, 3900 Burnway Drive, apartment 206, in Lansing, Ingham County, that you did willfully and maliciously destroy or injure a building or its appurtenances located at 3900 Burnway Drive, apartment 206, that belonged to a Joe Ella Chambers, and that the amount of the destruction or injury was less than $200, contrary to MTL 750.380. Count two is a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines, or 3 times the amount of this destruction, whichever is greater. However, sir, you are being charged as an habitual offender. Third offense notice. It says here, take notice that the defendant was twice previously convicted of a felony or attempt to commit a felony in that order about January 28th, 1998. He was convicted of the offense of carrying a concealed weapon. Are you okay, sir?
Yes, ma'am.
Okay.
I mean, ma'am, I know you're reading my charge and everything, but what this lady is trying to say
Martin,
is not what happened.
Martin,
And
Martin,
I'm gonna establish that because the simple
Martin.
fact, hold on,
no,
attorney.
no, you hold
I'm
on.
gonna establish
Listen,
that
until you-
because
Stop right now, because they're gonna tell you to stop talking because it's not your time to talk. After today, today's only for your arraignments, sir, not to argue.
I'm not arguing, sir. I'm just letting her know that all these.
Yeah, I can move on. I can move on. You know, this is a Saturday. I worked all week. If you don't want me to do your arraignment, you can sit tight until Tuesday when we come back in here. Okay?
Ma'am, I'm not disputing that. I'm just trying to explain to you what happened.
Did I ask for your explanation?
No, you didn't.
Okay, I asked you were you okay, because as I'm trying to read your charges to you, you were turning around as if something was wrong. And so if everything is okay and you're ready to proceed, then you remain quiet while I read the charges, and I will stop periodically to ask you if you understand or have questions about the charges and or your rights. But this is not an opportunity for you to present any defenses. Do you understand that?
Okay, thank you.
Your attorney, Mr. Nid, placed an appearance on the record on your behalf, and he's trying to counsel you because you have the right to remain silent, and anything that you say can be used against you. So he doesn't want you speaking or blurting out on the record without being properly counseled. Do you understand that?
I understand that, Mr. Judge.
Because you may say something that places you at the location, and that could be used against you. So learn to follow instruction, and when your attorney tells you to be quiet, do it. Okay. You are being charged as an habitual offender. Third offense notice. It says take notice that the defendant was twice previously convicted of a felony or attempt to commit a felony in that on or about January 28, 1998. He was convicted of the offense of carrying a concealed weapon under MCL 750.227 in the 30th Circuit Court, Ingham County, State of Michigan. And then order about January 28, 1998, he was convicted of the offense of operating while intoxicated, third offense, in violation of MCL 257.6256D in the 30th Circuit, and therefore the defendant is subject to enhanced penalties. That enhances your penalty under MCL 769.11 to twice the maximum sentence on the primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for a first conviction. Do you understand the charge that was read and the maximum penalty as well as the habitual offender third offense notice, sir?
Yes, I do, Judge.
Okay, you have the right to remain silent. Anything that you say can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, this matter will continue all the way through the prosecution up to a jury trial. You have the right to the presumption of innocence. So you're innocent until proven guilty, and you can take this matter to trial, but you have the right before that to have a preliminary examination on count one because it is a felony. You have the right to have that preliminary examination within 21 days of today's date. You have the right to require the prosecutor establish on the record sufficient probable cause that a felony was committed, and then probable cause sufficient to charge you as the individual who committed the felony. Do you have any questions so far?
No, ma'am.
Let me just interrupt. I don't think I received any criminal history for him either. Let me see if it was emailed to me. Okay, I'm not sure why this is the second file I don't have a criminal history on. Okay. Nonetheless, you have the right to be represented by counsel. You have the right to have an attorney represent you at all of your court appearances, and the right to have an attorney represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the public defender's office represent you at the expense of the public. Do you understand that?
Yes, ma'am.
Did you want the public defender's office to represent you, sir?
Yes, I do.
Okay, the court will note that you're requesting representation through the office of the public defender. I'm also going to enter a plea of not guilty on your behalf. I'm going to remind you again that you have the right to remain silent. Anything you say and anything you put in writing can be used against you. You can carry the right to silence through your jury trial, and you have the right to a jury trial. You have the right to the presumption that you're innocent until proven guilty. You can maintain silence at trial and they can't use that against you, or you can waive your silence and testify at your trial if you'd like. You have the right to see, hear, or question any witness called to testify against you, the right to subpoena witnesses to testify on your behalf. Do you understand those rights, sir?
Yes, I do.
You're currently scheduled for a probable cause conference before Judge Cynthia Ward on September 11th, 8 o'clock in the morning. You have a preliminary examination in person before Judge Ward on September 18th, 8:30 in the morning. Did you receive a notice to appear?
Yes, I did.
Oh, let's see. Are you currently employed?
No, ma'am. I'm self-employed.
Self-employed how?
Landscaping. I got a landscaping business.
What's your home number?
Your Honor, 48304. Did you ask for the address?
I'm asking for his address.
Can I say it?
What is your address? What is your address, sir?
Go ahead, give it to her.
48304.
But what?
Sorry.
Why can't he give it?
Again,
He doesn't know.
no,
Oh,
I think this
because I'm asking him because I'm verifying. Are you? What is your address?
4304 Madison. It's
Is it
MAC.
What is the name of the street that you live on?
I just said Magoo.
Okay. McGool, you
McDougal.
said? McDougal?
Yes, ma'am.
Is that it? Is it McDougal Circle?
That's
Is
4304.
that in Lansing?
Yes, ma'am.
What's your
Zip code
zip code?
48915. I mean 48911.
What's your phone
Sorry.
number?
I'll have one.
You do not have a telephone?
At the moment.
Are you on probation or on parole?
No, not that I know of.
Oh, okay. You can address bond court, counsel.
Your Honor, I'm asking the court for a PR bond with GPS tether, and if the court's not inclined, a low 10% bond. So Mr. Quesada can go back out. From my understanding, he reports he's self-employed doing side landscaping jobs. It's like on the spur of whenever he gets to the job. So it's not consistent, but he does maintain employment for himself. He disputes allegations in this matter, Your Honor, as indicated earlier with our not guilty plea. I just asked the court to take into consideration that this is an attempted home invasion, which I don't know what the allegations are exactly, the affidavit, but they raise question to why it was charged and attempted. So I'd ask under the circumstances and his limited history based on the HAP third. I know you don't have a criminal history, but the oldest being 27 years ago, to take that in consideration. Mr. Quesada just is a little upset of these false allegations, is what he reported to me. That's why there was that slight outburst this morning.
Mr. Quesada, do you have another case? Do you have another case pending right now?
No, this is all they gave me right here.
I have a bond recommendation from the prosecutor. They said that you're currently on parole, probation, or you have another criminal matter pending. I was not provided your criminal history, so I can't verify that, but I don't believe that I have no reason to believe that the bond recommendation is wrong. When I asked you, were you on probation or parole, you said not that you're aware of, but
No,
that doesn't mean no.
No, I'm not.
Is your office representing him on something else, Mr. Arnett?
I'm looking right now.
Judge, can I speak?
No, Your Honor. Not that I see of. Not that I see. No.
Yes, sir. Mr. Quesada, you had something you wanted to say?
Yes, ma'am. I know I shouldn't say this, but
No, don't say it then.
okay, all right, I won't. My thing is this, ma'am. I have never ran.
Okay, that's enough, Martin. That's enough. You're getting yourself. That's enough. We're all set.
Thank you. Bond is set in the amount of $2,000. Personal recognizance with GPS tether. You're not to be at the address at or near 206. I'm sorry, the address of 3900 Burnway Boulevard, apartment 306 or 206. You're not to be within 2,000 feet of wherever that address is. Do you understand that?
Yes, ma'am.
You're not to have contact directly or indirectly with a Joe Chambers. You need to report to all of your court dates on time. You're not to possess a firearm, ammunition, or weapon of any kind. You're not to use drugs or alcohol without a valid prescription. You're not to travel outside the state without prior approval of the court, and you must report to pretrial services within 48 hours of your release from custody, okay?
What, you said 48 hours?
Well, technically, you need to report by Tuesday because they're gonna be closed on Monday, okay?
Okay,
Do you have any questions?
no, ma'am.
Any additional matters for the record, counsel?
No, Honor.
You're all set, sir.
Thank you. Have a good day. Have a good weekend.
Same to you.
Are you gonna have, are we still gonna talk to you?
No, you're all set, sir.
Can I speak, can I still have
You're
a
all set.
word with
You
you?
gotta wait for the rest of the people. Let's go.
I'll try. I'll see if I
Thank
can afterwards. I'll try to. I'll try.
For the record, in the matters of the state of Michigan versus Brandon Leak. Appearance for the record.
George Annette, Assistant Public Defender, on behalf of Brandon Leak, who's appearing via Zoom this morning.
Are you Brandon Leak?
Yes, ma'am.
Okay, I have two files for you today, Mr. Leak. The first file is a felony complaint. The allegations are that on or about August 28th, 2025, at or near the area of Willow, near Martin Luther King Boulevard in the city of Lansing, Ingham County, that you allegedly committed the act in count 1 of police officer fleeing and eluding, 4th degree under the vehicle code. The allegations are that you did, being the driver of a motor vehicle to whom was given a visual or audible signal by hand, voice, emergency light, or siren by Trooper Andrew Morgan, a police officer who was in uniform and an officer's vehicle was identified as an official police vehicle, acting in the lawful performance of his duties, directing the defendant to bring his motor vehicle to a stop, did willfully fail to obey such direction by increasing the speed of the motor vehicle contrary to MCL 257, that is 0.602. That's a felony. Maximum penalty is 2 years and or $500 in fines, and the Secretary of State shall suspend your license for 1 year. There's an habitual offender fourth offense notice enhancing the sentence. It says, take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about March 22nd, 2017, he was convicted of the offense of breaking and entering a vehicle to steal property, $1,000 or more, but less than $20,000 in violation of MCL 750.356A2C1 in the 30th Circuit Court for Ingham County, State of Michigan. And that on or about March 22nd, 2017, he was convicted of the offense of breaking and entering a vehicle to steal property, 1,000 or more, but less than 20,000 in violation again of MCL 750.356A2C1 in the 30th Circuit Court for Ingham County, State of Michigan. And that on or about June 26, 2019, he was convicted of the offense of police officer flee and elude 4th degree in violation of MCL 257.60282 in the 30th Circuit Court, Ingham County, State of Michigan. Therefore, the defendant is subject to penalties provided by MCL 769.12, which would enhance your sentence to 15 years or less if the primary offense has a penalty under 5 years. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand the charge in that count and the maximum penalty?
Yes, ma'am.
Okay, the other file that you have is also a felony complaint. The allegations of that order about August 29th, 2025 at 2417 East Kalamazoo Street, City of Lansing, Ingham County, State of Michigan, that you allegedly committed the act in count 1 of controlled substance delivery, manufacturing, cocaine, heroin, or other narcotic less than 50 grams. It states that you did possess with the intent to deliver less than 50 grams of a mixture containing the controlled substance fentanyl or another narcotic in a Schedule 1 or 2 or drug described in MCL 333.72121H, 333.7214A4, or 333.7214A2, contrary to MCL 333.40012A4. This is a felony, maximum penalty, 20 years and or $25,000. A consecutive sentence may be imposed under the law for another felony conviction. This also has an habitual offender fourth offense notice. We've already gone through the prior charges from the first case that I read. It's the same 3 offenses that are alleged to have been convictions that you have that would enhance you now in this case to a maximum penalty of life, because the maximum penalty is in the original charge is 5 years or more. Do you understand the charge there and the maximum penalty in that file?
Yes, ma'am.
Okay, you have the right to be represented by an attorney. Mr. Anit is representing you today for your arraignment, but you have the right to have an attorney represent you at all of your court appearances, and the right to have an attorney represent you if you're questioned by law enforcement. If you can't afford to hire an attorney, you can request the public defender's office to represent you for free. Do you understand that?
Yes, ma'am.
You have the right to remain silent. Anything that you say and anything that you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute in each of these files, they will go all the way to jury trial. You are being charged with felonies in both files. You have the right to have a preliminary examination because they are felonies. And at the time of the preliminary examination, you have the right to have the prosecutor establish that they have sufficient probable cause that the felonies were even committed, and then probable cause sufficient to charge you as the individual who allegedly committed these felonies. In the file that charges you with police officer fleeing under the 4th degree, you are currently scheduled for a probable cause conference before Judge Tony Flores on September 11th at 9 a.m. and a preliminary examination before Judge Flores on September 18th at 9 a.m. In the other file that charges you with controlled substance delivery manufacturing, you are currently scheduled for a probable cause conference before Judge Stacia Buchanan at 8:30 in the morning, and a preliminary examination in person at the court before Judge Buchanan on September 19th at 8:30 in the morning. Did you receive your notices to appear, sir?
Yes, ma'am.
I will advise you that because the connection to these and because they're both filed at the same time, it's likely that there will be case consolidation and it will be transferred to one of the two judges that I just mentioned, okay?
Okay.
But your attorney will make you aware of that once you are assigned an attorney at the Office of the Public Defender. Those dates that you were just given for preliminary examination, you have the right to have them within 21 days unless you waive the 21 days or the court finds good cause to go beyond the 21 days. You have the right to the presumption, sir, that you are innocent. So you're innocent until proven guilty, and you can maintain your innocence and require the prosecutor prove your guilt by taking this matter to jury trial and requiring the prosecutor prove each element of the charges being brought against you beyond a reasonable doubt. You understand those rights?
Yes, ma'am.
At the time of trial, you have the right to remain silent. They cannot use the silence to prove or imply that you're guilty. You have the right to waive your silence and testify at your trial if you like. The right to subpoena witnesses to testify on your behalf or present evidence to show a defense to these charges. And you also have the right to see, hear, and question any of the witnesses called to testify against you. Any questions about your rights today, sir?
No, ma'am.
You have the right to be considered for pretrial release from custody. We'll address your bond in just a moment. Are you currently employed?
Yes, ma'am.
Where?
I work a side job with a friend named Mac. We do estate sales. They clean out houses around like the local East Lansing, Oakland Mills, Williamston, around the Lansing area.
When you say a side job, does that mean that you're paid under the table? Is that what you're saying?
Yeah. Paid under the table, 15 an hour.
Okay, what's your home address?
A 715 West Willow, apartment 105.
What's your phone number?
218-221-0487.
Are you currently on probation or on parole?
No.
Do you have any other cases pending?
I have court for unregistered vehicle on the 2nd.
You can address the court on bond.
Thank you, Your Honor. I'd ask the court to consider a PR bond. If the court is not inclined for a PR bond, a low 10% bond so Mr. Lee can be released and go back to take care of his mother, who he lives with at the time. He's also paying restitution in a juvenile file that he mentioned to me. So being employed and paying back restitution is important. So he can maintain employed, pay back restitution. Obviously, under these are only allegations. They have not been proven beyond a reasonable doubt. Looking at the two factors the court looks at, public safety and return to the court. To my understanding, Mr. Leak has not missed any court dates on his other files, is what he reported to me. Public safety risk. I understand the allegations are fleeing and eluding, Your Honor. Keep in mind that's a 4th degree, which is the lowest degree of fleeing and eluding that could be alleged. So taking that into consideration, Your Honor, I'd ask for a PR bond, if not a low 10% bond, Your Honor.
I do have a bond recommendation from the prosecutor's office. They're expressing concern about the protection of the public. Their indication is that the defendant is currently on parole. probation or has other pending criminal charges. When I look at his criminal history, I do see something in Meridian Township, but I don't know that he's been arraigned on that.
That's an unregistered vehicle in the store.
Okay, and then it also indicates that he has a record for non-appearance at court and proceedings or a flight to avoid prosecution. That's inherent in the actual charge that he's being charged with today, and also by prior conviction of the same exact type of charge, fleeing, eluding in the fourth degree. It says also that the people respectfully request a $20,000 cash surety bond. It says the defendant was arrested a day after fleeing from the police and being located later on in Lansing, this time with 20 plus grams of narcotics. Allegations include admissions to possessing the drugs for distribution. The people also request that the defendant be ordered not to engage in any assaultive behavior, not to use alcohol or illicit controlled substance, and to participate in substance abuse testing or program monitoring, and not to possess a firearm or any other dangerous weapon. I do believe under the circumstances, personal recognizance bond is not appropriate. Bond will be set in the amount of 10,000 cash surety on the file that he's facing up to life in prison. That is on the narcotic delivery manufacturer file. The bond in the other file, the fleeing and eluding, if I can find that sheet here. Our bond in that matter will be 10,000, 10%. The following conditions apply in both of the files. While on bond, you're not to travel outside the state without prior approval. You're not to use, purchase, or possess drugs, alcohol, or marijuana unless you have a valid prescription. You're not to possess a firearm, ammunition, or weapon of any kind. You must report to all of your court dates, and you must report to pretrial services within 48 hours of your release from custody. Do you have any questions at this time, sir?
No, ma'am.
Okay, any additional matters for the record, counsel?
No, Your Honor, thank you.
You're all set, sir. the matter of the state of Michigan versus Shamarick Biles. Council appearance, please.
Thank you, Honor. Good morning, good afternoon. George Ned, Assistant Public Defender, on behalf of Shamarick Biles, for purposes of arraignment only.
Are you Shamarick Biles?
Shamar Miles, yes, ma'am.
Ms. Shamarick, you said?
Yes.
Okay, Mr. Biles, today was the date that was scheduled for an arraignment. I do have a felony complaint here. The allegations are that on or about August 30th, 2025 at North Grand River at or near West Willow, Lansing, Michigan, that you allegedly committed the act in count 1 of controlled substance possession of methamphetamine and ecstasy. The allegations are that you did knowingly or intentionally possess methamphetamine contrary to Michigan Compiled Law 333.74032BI, and that's a felony with the maximum penalty being 10 years in prison and or $15,000 in fines. Do you understand the charge and the maximum penalty, sir?
Yes, ma'am.
Okay. You have the right to an attorney. Mr. Annette is going to represent you today for the purposes of your arraignment only, but you have the right to request the public defender to represent you at no expense to you, and you have the right to have an attorney represent you at all of your court dates and if you're questioned by law enforcement, okay?
Yes, ma'am.
You have the right in this matter to proceed to a preliminary examination. You are being charged with a felony, so you have the right to have that exam within 21 days of today's date, unless you waive that 21 days or the court finds good cause to go beyond the 21 days. You have the right at the time of the exam to require that the prosecutor put forth evidence that would establish that they have sufficient probable cause that a felony was committed, and then sufficient probable cause to charge you as the individual to have allegedly committed that felony. You are currently scheduled for a probable cause conference before Judge Cynthia Ward on September 11th at 8 o'clock in the morning. Preliminary examination is before Judge Ward on September 18th, 8:30 in person. Did you get your notice to appear?
Give me 1 second. Yes, I did.
Okay, and the purple sheet should be the instructions on how to log into her Zoom, okay?
Yes, ma'am.
Okay, again, you have the right to the presumption that you are innocent. So you're innocent, sir, until proven guilty. You can maintain your innocence, take this matter all the way through jury trial stage, and require the prosecutor first prove each element of the charge of controlled substance possession beyond a reasonable doubt. You have the right to be silent at your trial, and they can't use the silence to prove or imply that you are guilty, or you can waive your silence at trial and testify. You have the right to call witnesses to testify on your behalf. You have the right to see, hear, or question any witness called to testify against you. Do you have any questions about those rights?
No, ma'am.
Are you currently on probation or on parole?
Excuse me.
Are you on probation or on parole?
And another state, yes, ma'am.
In Philadelphia, Pennsylvania?
Yes.
What are you on probation for?
I'm on probation for.
I can't hear you.
I can't remember what I'm on probation for, ma'am. The cases are
You
so
can't
old. Right now, I can't
Your
remember.
criminal history is so robust that you can't remember what you're on probation for.
Right now, I'm in a little pain. So right now I'm going through pain of my health right now. So that's what's going on. That's why I'm saying I can't remember. My focus is on my health.
Okay, so you got something going on that you can't remember? Is this affecting you in any other way, whatever is going on?
Listen, you asked a question about my probation. My probation probably was for a civil possession. And I can't remember. I'm in pain.
Okay, I recognize you're in pain. You're saying you need medical assistance. Is that what's going on, or?
Just got out of the hospital.
Okay, you just got out of the hospital. Okay. Do you have any other court cases pending at this time?
I think so, yes.
You think so?
Yes, ma'am.
In Pennsylvania or in Michigan?
Think in Michigan, ma'am. It's a business of. Are you hearing me, ma'am?
I can hear you. Does the jail have his criminal history? Because it wasn't provided to me.
I can bring it up to you, ma'am.
Yes, please. Thank you.
You don't have
Okay,
to
and
warn
so. Thank you. You can bring it up, please. Thank you. What is your home address, sir?
I spent on the mission, ma'am.
I'm sorry?
I stayed at the rescue mission, ma'am.
At the rescue mission, you said?
Yes, ma'am.
Okay. Which one? The one on Michigan?
Yes, ma'am.
Okay. And do you have a phone?
Yes, ma'am.
What's your phone number?
517-243-2073.
Are you employed?
Right now, ma'am, no.
What brings you to Michigan, sir?
I came here for employment for Core-Mart. Core-Mart reneged on a job opportunity, and on my way to go back home, the state of Michigan took my child from me and my girlfriend, and I've been stuck here trying to get my child back ever since. That's what I'm here
Okay.
for.
Okay, so and you're on probation in Pennsylvania though, correct?
Yes, ma'am, but they know what I'm here for, so they'll hold me when I get back.
You have a pending family court issue with your child, you're saying?
Yes,
Here?
that's what I'm here. And that's what I'm in your state for. My child's supposed to sit back in Pennsylvania, and that's when I was going back home.
Mr. Nud, you can address the court on bond.
Thank you, Your Honor. I'm going to be asking for a PR bond today. The allegation in this case is not assaultive and does not indicate a threat to the public safety. And if anything, the allegation is a threat to himself. Mr. Biles has I believe, a stent in his heart, and he plans or wishes to go to the hospital upon release, unless the jail takes him before, or if he doesn't get a bond. He was in pain this morning, but we did conduct a intake properly without any issues. He is currently homeless. He will be residing at the city rescue mission. He does not he has a phone, he has an email, so we can get in contact with him. I believe that he will not be an issue, Your Honor. This is not a case that revolves around a victim or anything of that nature, so a PR bond would be appropriate. I don't have any information about in regards to failure to appear, flight risk, or anything of that nature.
He's got warrants in this state and other states, so that would mean that he is a flight risk.
He has warrants in this state?
That's exactly what I said. He's got warrants out of Eaton County, as well as out-of-state warrants. So a personal recognizance bond would not be appropriate. He's not able to provide me an address even in this state, or give the court reason to believe that he would stay in the state to handle this matter. I don't even know if he had permission to leave the state of Pennsylvania while on probation. I don't know that. But he's already on probation for possession. And then he's found here in the state of Michigan, allegedly in possession. Thank you. He's got a warrant out of Eaton County for possession of controlled substance as well as retail fraud 3rd degree, and he failed to appear in court. So a bench warrant was issued. So he'll be remanded on the bench warrant so that he can take care of his matters in Eaton County, and he will receive a 5,000 cash surety bond in this file. With GPS tether. He's not to leave the state without prior approval of the court. He's not to possess firearm or a dangerous weapon. He's not to possess any drugs or alcohol. He's got to report to pretrial services within 48 hours of his release from custody. Do you have any questions about your bond condition, sir?
I'm not, I don't understand it, man. I'm trying to
I can
understand.
repeat it. I can repeat it for you, sir. Your
Okay.
bond is going to be 5,000 cash surety on this, but only after you address your issue in Eaton County. So I'm remanding you to Eaton County, meaning you cannot be released from custody. Once your issue is addressed in Eaton County, I will convert the bond in this file to 5,000 cash surety. Do you understand that?
Yeah. Yes.
And that's because you have a warrant for failure to appear. You don't appear in court. And then you're picking up the same types of charges, not just in this state, not just in this county, but other counties in this state. And then you have the same alleged conviction, obviously, you have the same conviction in the state of Pennsylvania, and you're currently on probation.
Nothing further, Your Honor. Thank you.
You're all set, sir. Okay, let's see. State of Michigan versus Anya Dodge, counsel appearance. Mr. Nid, I don't know if you're muted, but we didn't hear your appearance.
I was sorry. George Annett, Assistant Public Defender, on behalf of Tanya Dodge, for purposes of arraignment, entering a plea of not guilty, Your Honor, and asking for court dates.
Thank you. Let's see, Miss Anya, you have a misdemeanor complaint here that alleges that on or about August 30th, 2025, you committed the act of domestic violence at the area of 1723 Bailey Street, City of Lansing, Ingham County, State of Michigan. The allegations are that you did make an assault or assault and battery upon a Stephen Trimmer, a resident or former resident of your household, or an individual whom you had a dating relationship, and that this is contrary to MTL 750.812. That's a misdemeanor, and the maximum penalty is 93 days in jail and or $500 in fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. You understand the charge and the maximum penalty, ma'am?
Yes, ma'am. Yes, ma'am.
Okay, you have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You can plead guilty, plead not guilty, or stand mute. Your attorney is entering a plea of not guilty on your behalf. Do you understand that?
Yes.
You have the right to be represented by counsel at all of your court appearances, and if questioned by law enforcement, if you can't afford to hire an attorney, the public defender's office can be appointed to represent you at the expense of the public. And then Mr. Ned has also indicated to the court that you are requesting representation by the Office of the Public Defender. And so the court has entered a plea of not guilty on your behalf and noted that you are requesting public defense representation. You have the right to take this matter to trial. You have the right to a jury trial. You are presumed innocent until proven guilty. You have the right to require the prosecutor prove each element of the charge of domestic violence beyond a reasonable doubt. You have the right to be silent at trial, and silence can't be used against you. You have the right to call witnesses that would testify at your trial on your behalf and to present evidence at trial that you believe show a defense to this charge. And you have the right to see, hear, or question in court any witness the prosecutor calls to testify against you. Do you have any questions about those rights?
No, ma'am.
You have a pretrial conference before Judge Cynthia Ward, September 16th at 10:30. You should have received a notice to appear and instructions for her Zoom court. Did you receive that, ma'am?
Yes, ma'am. Yes, I did.
What is your home address?
I'll have a home address. I have a friend's address that I'm staying at. I'm homeless right now. And it's 2265 West Parks Road, St. John, Michigan, lot 142, 143, sorry.
You said in St. John's?
Yes,
That's a friend's address?
Yeah.
Are you employed?
I am, but I'm on medical leave right now because I have seizures.
Do you have a phone number?
Right now, I do not, no.
Are you on probation or on parole?
Okay.
Do you have any other cases pending in any other courts?
No, ma'am.
Bond is set in the amount of 500 personal recognizance. There is a no contact order in place for the protection of Stephen Trimmer. You're not to be within 2,000 feet of wherever he is, okay?
Can I ask a question, Your Honor?
Absolutely.
My medication and most of my stuff is at his house still. I haven't had my medication yesterday. Is there a chance maybe I can go to the hospital to get medication, or how can I get that?
You want to know if there's a chance if you can go to his house to get your medication?
Yeah, or I go to the hospital to get medication because I'm not feeling very good.
Well, I'm going to release you from custody so you can go to the hospital if that's what you need to do. And I will allow you to send a third party to get your medication and other things from Mr. Trimmer's address if that's what you need, but you can't do it yourself, okay?
I would like that. Thank you so much, Your Honor.
Okay. You need to report to all of your future court dates, and you need to make sure that you don't travel outside the state without prior approval of the court. No alcohol or drugs unless you have a valid prescription. Again, no contact directly or indirectly with Mr. Trimmer, except, again, you may send a third party to get your personal belongings, okay? Do you have any questions at this time, ma'am?
Well, ma'am, thank you so much.
No problem. Any additional matters, counsel?
No, Your Honor, thank you.
You're all set. On the record, in the matter of the state of Michigan versus Jamarquez King. And I have file number 20-03434. Appearance, please.
Thank you, Your Honor. George Ned. Thank you, Your
Good
Honor.
afternoon, Your Honor.
George Ned, Assistant Public Defender on behalf of Jamarquez King for purposes of arraignment only. Your Honor, we did conduct an intake this morning for the Public Defender's Office and rendering a plea of not guilty at this time.
Okay, you are Mr. Jamarquez King, correct, sir?
Yes, ma'am, I am.
Okay, I do have a misdemeanor complaint. It alleges that on or about August 21st, 2020, at the area of 704 West Kalamazoo Street in Lansing, that you allegedly committed the act in count 1 of domestic violence upon a Nadia Matthews, a resident or former resident of your household or individual with whom you had a dating relationship. And this was in violation of Michigan Compiled Law 750.812. The restitution may be ordered as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. And that is a misdemeanor, maximum penalty 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charge, sir, and the penalty?
I do, Your Honor.
Okay, you do have the right to counsel. Mr. Nid has advised that you have requested the representation of the Office of the Public Defender for this purpose, so the court will note that. You have the right to plead guilty, plead not guilty, or stand mute. And Mr. Nid has also advised that you are maintaining your innocence at this time, and so the court will enter a plea of not guilty on your behalf, okay?
Understand, right?
You are presumed innocent until proven guilty, and you can carry that presumption all the way to jury trial. You have the right to have the prosecutor first prove each element of the charge being brought against you beyond a reasonable doubt. You have the right to be silent at trial, and they can't use that silence to prove that you're guilty or imply that you're guilty. You have the right to call witnesses to testify on your behalf at trial or present evidence that you believe show a defense to this charge. And then you also have the right to confront and cross-examine in court any witness called to testify against you. Do you understand those rights?
I do, Your Honor.
You're scheduled for a pretrial conference before Judge Stacia Buchanan on September 22nd at 2:30. You should have received a notice to appear and the Zoom instructions. Did you get those, sir?
Yes, Your Honor, I did.
Are you currently employed?
No, Your Honor, I am not.
How do you support yourself?
Actually, I lost everything coming to turn myself in.
You said you lost everything coming to turn yourself in, but how does that happen?
I lost my apartment, my job, and because I had to turn myself in Kalamazoo. So I lost everything.
Okay, so you're not talking about turning yourself in on this case.
On all the cases. Yes, I am, Your Honor.
I'll elaborate. I can elaborate.
Okay. Okay, yeah, because I'm not following. Did you he just turned himself in today? I'm not following what's going on.
Well, my understanding is he had some old files. He turned himself in on when he was made aware of I believe a probation violation that stemmed maybe 4 or 5 years ago. Correct me if I'm wrong, Mr. King. Turned himself in, handled everything, got unsuccessfully discharged, but he's done with probation in Kalamazoo. He was found out about this, got transferred over here, and here we are, Your Honor, a 5-year-old case.
Okay, yeah, well, just because the warrant sat for 5 years doesn't mean that it waters down the allegations. Let's be clear there. I do see on his criminal history that there was a probation that was revoked in Kalamazoo, that he was placed on probation, it looks like in 2018. I see that there was a 2019 case in the 3B district court that was bound over to the circuit court that does not have a disposition, so that I'm inclined to believe that that has not yet been resolved. It looks like there was a 2019, and also in Kalamazoo, motor vehicle case, unlawful driving away, that he got 18 months probation. I don't know if that was connected to the one that he was just discharged or revoked from, because it does appear that the timeframes are similar on that. And then looks like there was a Kalamazoo on August 25th requested a warrant. You turned yourself in, sir?
Yes, ma'am, I did.
Or were you picked up on a warrant?
No, I turned myself into the Kalamazoo County Jail Sunday night around 10 o'clock p.m.
Okay, sounds good. And so that must have been the August 25th warrant requested on a 2022 file. And then there's this file that's been in warrant status since 2022. Nonetheless, you do have the right, again, to the presumption that you're innocent. You say you're unemployed, so you left your job so that you can turn yourself in on these warrants, is what you're indicating?
Yes, ma'am, I did.
And then, do you have a home address?
I do have a home address now, yes.
What is that?
2500 St. Albans Way, Kalamazoo, Michigan, apartment 114, and zip code 49048.
Okay, and do you have a phone number?
269-998-3014.
Okay, is he gonna be serving time in Kalamazoo now, or what happened when his probation was revoked, counsel?
From my understanding, Your Honor, and Ms. can correct me if I'm wrong, I think he just got a fines and cost, it's unsuccessful discharge. With no further.
No fines. I'm sorry, Ron. I have no fines, no costs on that. I'm actually discharged from everything. They just, time served.
Okay, due to the age of the case, as well as the fact that you turned yourself in on your warrants, the court's going to grant a request for a personal recognizance bond. Bond is set at 500 personal recognizance. There is a no contact order in place for the protection of the alleged victim, Nadaya Matthews, okay?
Yes, ma'am.
You're not to have contact directly or indirectly with her. You're not to be within 2,000 feet of wherever she lives, works, goes to school, or handles any of her business. You must report to all of your court dates. You should have received Zoom instructions, so you do have the ability to report to your next court date via Zoom, okay?
Yes, ma'am.
You do have the Zoom instructions though, correct? I don't know if you confirmed that. You did get
Yes,
that?
ma'am, I do.
Okay.
Yeah.
Right. Also, while out on bond, you're not to travel outside the state without prior approval. You're not to possess a firearm, ammunition, or weapon of any kind. You're not to use alcohol or drugs without a valid prescription. And again, you need to report to your court dates. Do you have any questions at this time?
No, Your Honor, I do not.
Any additional matters for the record on this file?
No, Your Honor, thank you.
Thank you, sir.
Yep, have a great day.
Same to you. On the record in the matter of the state of Michigan. Is this state of Michigan? No, this is the city of Lansing. City of Lansing versus Crystal Wojciechowski, 21-03437 OD. Appearance, please.
Thank you, Aaron Georgia Nid, Assistant Public Defender on behalf of Crystal W. For purposes of arraignment only this afternoon.
Okay, let's see. I have for you, is it Wojciechowski?
Yes, ma'am.
Okay, I have here a file alleging that you essentially absconded from your probation status. It looks like you were placed on a term of probation before Judge Buchanan. She sentenced you to 9 months probation, which was her last note. There is a warrant here in this file alleging that per AverHealth, you tested positive while on probation on October 16, 2024, with 1,218.92 nanogram per milliliter ETG and 401.43 nanogram per milliliter ETS, and then 303.5 nanogram per milliliter of Nordazepam, and then 325.41 nanogram per milliliter of Oxapam, and then 507.6 nanogram per milliliter of Temazepam, and then it looks like 69.602 nanogram per milliliter of carboxy THC, 1,000 nanogram per milliliter of benzo, and 1,906.653 nanogram per milliliter of oxycodone, and then 685.868 nanogram per milliliter of oxymorphine. And so you have the right to a contested hearing on those violations. There's another violation here that alleges that you failed to provide proof of a prescription for the positive test that you had on October 16, and that you failed to submit to your random testing at EverHealth and failed to test on October 18th, 2024, October 20th, 2024. You have the right to a contested hearing on all of those violations and the right to be represented by an attorney. You have the right, let's see here, is this the same one in this file? I think it's the same one. Yep, you have the right to be represented by an attorney at the contested hearing, and the right to have the prosecutor on this file and the probation department put forth evidence to support these allegations before you're found to be in violation of your probation status. Do you understand your right there, ma'am?
Yes, ma'am.
What's your home address?
2916 Averill Drive, Lansing, Michigan, 48911.
Are you employed?
Yes,
Where?
Grand Haven Living Center.
I repeat, where you're employed again, you said?
Grand Haven Living Center.
Oh, okay. What do you do there?
CNA. Caregiver.
What's your phone number?
I-17-299-3191.
You can address bond, Mr. Aned.
Thank you, Your Honor. In looking in Crystal's file, I've noticed that she's been coming to court on a felony file that's either been dismissed or in the circuit court. I can't tell from my notes on a felony charge. I'm in regards to why she didn't know about this probation violation stuff. That's we did not really discuss that, but just a little confusing to me why it's now coming up and she's been pending and coming to court throughout the year from the way my notes look. In regards to bond, Your Honor, she'll be coming back to court. She is now living with her husband's mom, so her mother-in-law and her 5 children. She's working, take care of the family, and in the process of trying to find a place to stay with her husband, and her 5 kids. I asked that she be released to go back to work, take care of business, and she'll be coming back to court. She won't be an issue, Your Honor, in regards to my consultation with her this morning.
You said she's been coming to court on a felony file. What does that mean?
Based on what I see, she's been coming to court. Let me see. It looks like back on April, May, July, August. And again, based on my notes, it looks like there's been court dates on a felony file with Sarah Donnelly being the attorney of record on a felony file, and now these probation violations are coming up. I'm not sure why they just came up now and they didn't come up during the course of this year, especially this is a 2024 case. Me and Crystal did not talk about that. I just came to my mind as I was looking at her files.
Yeah, this warrant's definitely been in the system, and it's got a pickup within 100 miles. It's been that way for some time, and she's not been reporting to probation. She's not been discharged from probation. She knew she was on probation. So I don't know. I don't know why she would go to court on another matter and not show up on her probation on this file. She has a long history on this file of failure to appear. And I recognize the cases from 2021, but the reason why it lingered was her fault. She failed to appear in January 2022, failed to appear in March 2022, failed to appear September 2023. And so Judge Buchanan's been trying to track her down for quite some time. It looks like the bench warrant requests the bond to be set at $25,000 cash. Let me see here. That's got to be a typo. Let's see here. It's not a typo. She requested $25,000 cash surety on this bond.
Okay. Crystal, I just have a quick question. Were you the felony file we talked about? Was that in front of Judge Buchanan or was that a different judge?
It was a different judge.
Oh, okay. And I'd ask to consider maybe a lower bond.
I'm going to consider a low bond because that's a bit intense for a OWI. Let's see here. I will set the bond in the amount of $10,000, 10%.
10,000, 10%.
10,000, 10%. And she needs to report to all of her court dates. Any additional matters for the record?
No, Your Honor, thank you.
You probably need to check in with your probation officer immediately.
Thank you.
You're welcome. That's all I have.
Your Honor, have a good weekend.
Same to you. I'll be here tomorrow too, but you have a good one too.
Thank you. Thank you.
Thank you.